Hello and Assalamualaikum. In this video, we would like to talk about repossession under Hire Purchase Akta 1967. The presenter in this video is Alia Syazlina binti Muhammad Fadzil, Aufa Nazihah binti Muhammad Ajiji, Nureen Sofiah binti Roslan, and Robiahtul Adawiyah binti Mizan. And our lecturer is Miss Kausa Ismail Anunu. We would like to present about first introduction about repossession under Hire Purchase Akta 1967, second grounds of repossession and issue, third procedures of repossession, and the last one is conclusion. Hello, Assalamualaikum. My name is Alia from DPM 5A. In this video, I would like to talk about introduction repossession under Hire Purchase Akta 1967. Okay, the Malaysian Hire Purchase Akta 1967 provides several reminders to the owner of goods laid out on hire purchase in case of a breach of the hire purchase agreement by the hire. Repossession of the hire purchase good is one of reminders. Repossession occurs when the hire has deferred in the payment of installment. In reality, repossession of the hire purchase goods strike at a core feature of hire purchase transaction occurs when the hire has deferred in the payment of installment. In reality, repossession of the hire purchase goods strike at a core feature of hire purchase transaction. It denies the hire the possession of the hire purchase good. Therefore, the remedy of repossession is not likely administered. Repossession entails the good instead of being in the custody of the hire finding their way back to the owner. Upon repossession of the goods by the owner at once has possession of and property in the goods. From the hire finding their way back to the owner. Upon repossession of the goods by the owner at once has possession of and property in the goods. From the perspective of the hire, upon the owner repossessing the goods, the hire loses his possession and the use of the hire purchase goods. Since the paper focus on the remedy of repossession, which is available to the owner of goods under the Malaysian Hire Purchase Akta, it is important to point out from the very beginning that recent amendments were made to the Akta in 2010. The amendment came into force on 15 June 2011. I will present about to examine the safeguards that have been put in place in terms of the exercise of the right to repossess the hire purchase good by the owner. The presentation also highlights some of the controversy dogging the remedy and suggests some solution which may occasion a revision of the Hire Purchase Akta. This presentation is divided into 4 parts excluding the introduction. The first part deals with the meaning and nature of hire purchase transaction. This part of the discussion is important as it will go on to show how hire purchase transaction is different from the contract of sale goods. Furthermore, the second part is issue of repossession, and the third part is process repossession, and the last one is conclusion. Meaning and nature of hire purchase transaction. A hire purchase transaction is basically an agreement wherein the owner agrees to hire good to the hire with an option for the hire to purchase the good. Generally, hire purchase means obtaining the benefit of the possession and use of good before one has fully paid off them. Okay, that's all from me. I will pass to my friend. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nureen binti Roslan from class DPM 5A. In this video, I would like to talk about ground of repossession and issues under Hire Purchase Akta 1967. Okay, for the grounds of repossession, ground 1 is repossession of own residence. Okay, people often rent out their home when working abroad or going extended travel, and they would naturally expect to return to life in their own on return. However, tenants are entitled to security of tenure for the contract term, which is safe in the knowledge that they can stay in the property for the length of their contract. Okay, for ground 1, about Housing Acta 1988 Section 8 Schedule 2 allows a landlord to regain possession, but it is a prior notice ground, which means the tenant must have been given a notice informing them that ground 1 applies before the start of tenancy, and as the landlord maybe asked for proof as a proof that the notice was given. If the ground 1 is to be invoked, it is prudent to get a signed statement from the tenant to say that they have received and understood the notice. Okay, and then the ground 1 is one of the mandatory ground under Schedule 2, which means the judge, unlike the discretionary grounds, must issue a possession order providing the prior condition are met. As with all the other grounds under Section 2, a notice must be served on the tenant prior to applying to the court, setting out the reasons for the possession claim in the exact wording as stated in Acta. The particulars of claim, a landlord using repossession grounds under Section 8 must always ensure that they do more than simply state ground 1. For the example, they must specify the full text of the ground relied upon. In the 2 previous court cases where the grounds were stated rather than specified, the claims for possession were dismissed. The landlords and agents should carefully follow the requirements of Practice Direction Part 55 under the Civil Procedure Rules when making a possession claim. Okay, other than that, the advantage of relying on Section 8 Ground 1 is as opposed to Section 21 that the notice period is much shorter, 2 weeks as opposed to 2 months. The Section 21's possession process, of course, is due to not likely occur for a couple years, and it will not likely apply to existing tenancies. They have two instances where ground 1 may be used is like the first one is when returning to a property which before it was rent out, the landlord meant resident, and the second one is ground 1 can be used even if the landlord never lived at the property before, providing it can be shown that the landlord intends to live there afterwards.
Assalamualaikum warahmatullahi wabarakatuh. My name is Robiahtul Adawiyah binti Mizan from DPM 5A. I would like to produce my presentation is my topic, the procedure of repossession. The first one is banking institution give foreschedule notice 21 days to inform your debts its intends to repossess the vehicle. Okay, the example, banking institution can repossess the motor vehicle anytime after 21 days from the date the foreschedule notice were served if the overdue installments are not paid. Okay. The second is the banking institution gives second notice to inform your its intentions to repossess the motor vehicle. And the third, banking institution repossess the motor vehicle upon the expired to forescheduled notice. For example, if you settle your outstanding balance early, you are entitled to recover your motor vehicle within the stipulated time. Okay, the next is banking institution give 5 scheduled notice hire to exercise right within 21 days.
For example, is after the repossession, your banking institution will issue your fifth shoulder notice. This notice will give you a chance to settle the amount outstanding within 21 days. You can get the motor vehicle back provided that's before the expiry of 21 days. Okay, the last one is banking institution sales motor vehicle open expiry of 5 shoulder notice.
Hi, Assalamualaikum. My name is Aufa Nazihah binti Ajiji. I would like to talk about conclusion of repossession under hire purchase. Okay. It is evident from the above discussion that the owner has the right to repossession of the hire purchase goods in the hire commits a breach of his obligation under the hire purchase agreement. Usually, non-payment of installment. The governing statute on hire purchase in Malaysia has been around for some time. To its chapter, the important remedy of repossession, that non-payment of installment. The governing statute on hire purchase in Malaysia has been around for some time. To its chapter, the important remedy of repossession, that the owner can exercise in a hire purchase transaction. There are gaps to fill in its provision regarding the enforcement of this all-important remedy available to damnified owner. There is no doubt, however, that the provision of the Act seem to be overprotective of the hires. For example, the consequence of non-compliance with Section 60 by the owner tends to create an imbalance in the scale of justice in hire purchase agreement. This is by virtue of Section 60, which imposes a penalty on the owner who failed to serve a Section 60 notice. The right of the owner under the hire purchase agreement would change and determine. It would seem that the owner would not be able to enforce any remedy given to him by the agreement to recover any amount from the hires. However, if the hires exercise his right under this Act to recover the goods repossessed by the owner, the agreement will have some force and effect in relation to the right and liabilities of the owner and the hires as it would have had if the notice had been duly given. Thus, it is hereby recommended that Section 60 of the Act should be amended in order to remove the kind of imbalance in the scale of justice as far as hire purchase transactions are concerned. Okay, that's all from me and that's all from my group. Thank you.